Hello, I'm William Robinson, Insolvency Officer at Waterstone Insolvency, and this is Greg Sherriff, Licensed Insolvency Practitioner. Today we're going to be discussing issues to be considered by new business owners. So Greg, what do you consider the profile of a typical new business?
Usually the startup businesses are done by a person that's really proficient in the field of industry, that's in relation to construction or retail, engineering, or something of that ilk. They often don't cover all the bases, is the administrative side of the business. So they're expert in what the core function of the business, but they might fall down on ensuring that the business is properly structured and with the proper administration in place.
What issues should be considered by directors?
Well, a primary issue is to, I would suggest, consult an accountant to set up a basic structure to make sure that the business operates on the right track, set up an accounting package such as Xero or some other accounting software package. This will enable the business owner to keep track of how the business is functioning on a day-to-day basis. He'll be able to determine if the business is at risk of not being able to meet its debts as they fall due, or whether the business is suffering any cash flow problems.
If no proper structure has initially been set up, can this be rectified?
Well, it's not too late, depending at what stage they seek for help. But if a business owner feels that his business is floundering a bit and he's not sure what to do, he should consult a professional. It could be an insolvency professional or his accountant, who could advise him, look, your business hasn't been properly structured, you've got to get this in place, you've got to know exactly how your business is performing on a day-to-day basis so you can keep control of it.
What are common causes leading to the failure of a company?
As I said, the failure to maintain a proper accounting system is a common cause in a number of liquidations I've encountered. Often directors are so focused on what they're doing, they can't keep control of the cash flow. Not knowing whether accounts receivables are being paid timelessly or allowing them to get to 90 days or beyond, and becomes harder and harder to collect. There's a flow-on effect. This means inability to meet debts when they fall due, and often the RD is the fall guy, and so pay as you earn doesn't get paid when it should, GST doesn't get paid when it should. It starts creating a large hole with the RD that often becomes too deep to dig themselves out of.
So what issues would a liquidator typically investigate?
The primary issues a liquidator would normally investigate would be the conduct of the directors prior to liquidation, in the period leading up to liquidation, whether their conduct contributed to the liquidation in any way. If so, whether there's a claim against the director in that regard.
Does the liquidator necessarily have to report to any authority?
In terms of the core function of the business, report to various authorities. In terms of the Securities Act, Security Markets Act, the Financial Markets Act, the Crimes Act. So if a liquidator uncovers any suspicion that these acts have been contravened, he has the duty to report that to the relevant authorities.
And finally, what duties should directors be aware of when running a business to avoid running foul of the liquidator?
Sections 131 and 135 to 137 of the Companies Act set out the duties that directors should be aware of, and they are the duty to act in good faith, the duty to avoid trading recklessly, incurring debts without any expectation of paying them, the duty to have regard to an obligation incurred on behalf of the company, to be able to perform that obligation, has a duty of care to the company, and overriding that, in my view anyway, is the duty to maintain proper accounting records, which should be maintained sufficiently so that the nature of every transaction entered into the accounting record is able to be adequately described and explained. And more than that, the director should be able to at any time have access to those financial records or accounting records to determine the state of the business and how it's tracking. Essentially, the financial performance of the business should be able to ascertain at any time of the running of the company. And the failure to comply with those duties could result in severe penalties for directors. With accounting records, you could face a failing to maintain them adequately. If prosecuted, you could face a fine up to $10,000. And on top of that, if the liquidator goes after a director for failure to maintain proper accounting records, directors could be held liable for certain or all of the debts of the company. And in relation to the breaches of Section 131 and 135 to 137 of the Companies Act, if a liquidator attempts to hold a director to account for breach of those duties and succeeds, directors could also be required by the court to make a contribution to the company to cover certain debts of the company. So potentially harsh penalties for directors for failing to observe the basic duties in running the affairs of the company. However, this doesn't have to be an alarm story, because if directors are doing the right thing, they should have no fear of having a gun held to their head by a liquidator coming after them for transgressions of the Companies Act. We must remember that a lot of our liquidations also aren't necessarily due to the failure of the company's director to maintain proper books of account or acting in breach of their duties. It could be a knock-on effect from a large debt outstanding to them, and that company goes into liquidation, and suddenly that really affects their cash flow, because they were expecting to collect that amount. Now suddenly they can't pay the creditors that they've been put off in expectation of having received that amount. So there are other factors as well, and no one will then go to the director and say, hey, you've breached your duty because you didn't collect this money. Directors need not have any sort of concerns in that regard. It's just where they've usually been willfully in breach of their duties as a director and failed to maintain the books of account in a proper and orderly manner, so that they can be properly examined to determine the financial position of the company at any stage of its performance.
Well, that concludes our video today. If you have any questions about liquidations or receiverships or insolvency in general, please email enquiries@waterstone.co.nz or call our 0800 free number 0800 closed. Thank you.
Thanks.